Okay, good morning, everyone. Thank you for joining us today for this Radcliffe Talks Charities event. Matt and I are very pleased to be here, and we hope that you'll find the next hour or so to be both informative and interesting. In terms of the format, Matt's going to speak first on the subject of conflicts of interest, including an outline of the upcoming updates to the Charity Commission's guidance. Then I'll be talking through ex gratia payments in light of recent updates to the Commission's guidance. At the end, we hope there'll be time for questions, and if there is anything you'd like to ask, then please write it down in the Q&A function on Zoom. You can do that throughout, but as I say, we'll come to them at the end of both talks. So I'll now introduce Matthew Mills. He's a barrister specialising in private client, charity, property and insolvency cases. Matthew's on the Attorney General's C panel. He's ranked as a leading junior by both Chambers and Partners and Legal 500, and in 2025 he was named Public Services and Charities Junior of the Year by Legal 500. So he really does know what he's talking about when it comes to charity law, and I'm very much looking forward to hearing from him today. So without further ado, Matt, I'll hand over to you.
Thank you very much. This is a talk about conflicts of interest. Now, trustees have been getting in trouble about conflicts of interest for over 300 years. So why am I only talking to you about this now? Well, in my view, conflicts of interest are important today for three reasons. Firstly, they're very topical. For example, in 2025, a number of reported cases discussed conflicts of interest, including 2 Supreme Court cases. Also, just last week, the Charity Commission opened an inquiry into a substantial charity about concerns over unmanaged conflicts of interest. And later this year, the Commission's going to give us updated CC29 guidance on conflicts of interest. The second reason why I say conflicts of interest are important now is that the consequences of getting this wrong can be very severe, and I'll talk about this towards the end of my talk. And the third reason is that conflicts of interest can arise throughout a charity's life cycle. And that's what I'll turn to next. Conflicts of interest are relevant from the beginning to the end of a charity's life. For example, when considering an application to register a new charity, the Commission will look at the clauses relating to conflicts of interest in the governing document. Later, the Commission may give advice or authorisation in relation to a conflict of interest which arises during a charity's activities. For example, this may arise out of trading or a potential sale. And if you want to merge 2 charities and ask the Commission to authorise an indemnity for the old trustees, the Commission will again consider conflicts of interest. Now, the principles which I will talk about today apply to fiduciaries. Now, the most obvious example of a fiduciary is a charity trustee. But depending on the circumstances, the things I'm going to talk about today may also apply to CEOs, members, senior employees, agents, or even third parties who have powers under the governing documents to do certain things, say appoint or remove trustees. Now, in most cases, only the trustees will owe fiduciary duties, so only the trustees will need to think about conflicts of interest. But there will be cases where some or more of these people will need to think about it as well, so do bear that in mind. But for simplicity, instead of listing these 6 people every time, I'll just talk about trustees. So that's why I say conflicts of interest matter. Topical, important, cover lots of people. But what are they? Well, in the Children's Investment Fund Foundation case, the Supreme Court gave this helpful summary of the law. In a nutshell, there are 2 main principles. Firstly, a trustee must not put themselves into a position where their interests conflict with the duties they owe their charity. And secondly, a trustee must not make an unauthorised profit from their position as trustee. Well, that all sounds rather straightforward. Why are we having a whole webinar on this? Well, let's dig into the detail a bit. I'm going to start with the first of those principles, conflicts of interest and duty, and I'll discuss what each of those key words means. And I'll start with interest. It's almost impossible to give a comprehensive definition of a relevant interest, but a leading Australian judge has given it a good go. And he said it covers some personal concern of possible pecuniary value, which is very difficult to say, but I did practice. For example, this would cover actual or potential profits or benefits, as well as actual or potential savings of expenditure. Now, most cases involve financial interests because they're the clearest cut and easiest to prove, but the no conflicts principle also applies to non-financial interests, things like family obligations or professional opportunities. Now, there is no fixed list of non-financial interests which might engage the no conflicts principle. In all cases, what you need to do is step back and say, is there a real risk of a conflict between this non-financial interest and the duties the trustee owes their charity? Importantly, the interest which is engaged doesn't need to be held by the trustee. It can be a connected party's interest. Now, at common law, there is no fixed list of connected people who are automatically within the scope of the rules. But in practice, the Charity Commission is likely to rely on the list of connected persons given in various sections of the Charities Act. In simple terms, that list includes close family members, spouses of trustees and close family members, business partners, and another company or charity in which the trustee has a substantial interest. So those are really the most obvious examples of connected people who might fall within the scope of these rules. So that's the word interest. What about duty? In a nutshell, this refers to the function, the responsibility the fiduciary has. Now, in the charities context, that's likely to refer to one of the duties that are discussed and set out in CC3, the Charities Act, and/or the Companies Act. Hopefully, your clients will all be familiar with their basic duties as charity trustees, so I won't say any more about them. But if you do want an introduction, there is a webinar on the Radcliffe Chambers YouTube channel, which I gave in 2020, along with Robert Pierce Casey, on trustees' powers and duties. So feel free to click on that and have a look. So that's interest, that's duty. What's a conflict? Again, I can't give you a precise metric or test, but the key point to take away is that the threshold is very low. For example, one of the leading cases uses the phrase possibly may conflict. This has been said to mean that a reasonable person would think there is a real, sensible possibility of conflict, rather than a mere theoretical possibility. But there is still a threshold. It's not everything that's caught. That means it is possible to have such a trivial interest in something that the no conflict principle is not engaged. Perhaps one share in the company Apple, which has so many shares. But it's pretty exceptional for you to be accused of a conflict of interest and able to get out of it by saying it's de minimis. So those are the key words: conflict, interest, and duty. They're all rather vague and academic, aren't they? Let me give you some examples to try and help put this into practice. Conflicts of interest might arise, for example, during discussions about trustee remuneration, or discussions about a potential sale or lease of a property, either from a charity or to a charity, or perhaps a loan if a charity needs money or wants to give money to one of its trustees. And it might also involve a transaction between two charities. For example, one of your charity trustees might also be a trustee of the receiving charity, or might be a beneficiary or live within the area of benefit of the receiving charity's scope. So those are fairly common examples of conflicts of interest. This is principle one, no conflicts. Let's move on to the second principle the Supreme Court mentioned, no profits. This principle is straightforward and intuitive. In a nutshell, a trustee is not, unless expressly provided, entitled to make a profit from their position. But what do we mean when we say a trustee has made a profit from their position? Again, there is no definitive answer to this essentially causation test, but probably the best test was set out in Chan Zachariah. Any benefit or gain by reason of or by use of your position as trustee, or of any opportunity or knowledge resulting from it. Now that's obviously and intentionally very broad. Now, if you think that you might fall within the scope of this test, please remember the no profit principle is very strict. For example, it doesn't matter that the charity suffers no loss. In fact, the trustee might still be liable even if the charity benefited in some way. It also doesn't matter if the trustee acted fraudulently or not. In fact, the trustee might be liable even if they had the best of intentions and thought they were doing the right thing. It's a very strict principle, so please be very careful. Let me give you some examples to put this into practice. A trustee might breach the no profit principle if they receive payment, even below market rent, for goods or services they provide a charity, maybe cleaning services, accountancy services, property management, or physical goods like materials or food. Another example would be if a trustee obtains a position of paid employment as a result of being a trustee. Say they become a director of a trading subsidiary with a salary, or maybe a director of a connected management company. Another example would be if a trustee obtains some kind of benefit from being a holding trustee of the charity's property. Also, don't forget, a trustee can still fall within the scope of the no profits principle, even if the profit is made by a third party. For example, this came up in the Children's Investment Fund Foundation case, where Charity A was considering making a grant to Charity B, but one of the members of Charity A was a trustee of Charity B. That could have fallen within the scope of this principle, and certain processes needed to be followed. I'll talk about those in a bit. So those are the general equitable principles, the things you find in the case law. I now want to briefly summarise the fairly similar statutory principles that apply to companies and CIOs. For charitable companies, the no conflicts principle and the no profits principle are codified in sections 175 to 177 of the Companies Act. In particular, the no conflicts principle is in 175(1). In a nutshell, a director must avoid a situation in which he has or can have a direct or indirect interest that conflicts or may possibly conflict with the interest of the company. Lots of that sounds familiar, doesn't it? Now, importantly, this applies to conflicts of interest and what we call conflicts of duty. Now, that arises where you owe two different entities or two different people a fiduciary duty. For example, if you are a director of more than one company, a trustee of more than one charity. For this reason, best practice dictates that if you're a director of one charitable company and you want to work for another charitable company as a director, and those interests may possibly conflict, you should get the authorization of Charity A first, the first charity. Now, generally, just like in equitable principles, this is applied strictly. It doesn't matter if you have good faith, it doesn't matter if you have bad faith. But there are three statutory exceptions here, which is where the law slightly differs from the common law. For example, section 175(1) doesn't apply if the charity's constitution expressly disapplies it in the relevant circumstances. Similar to equity, section 175 is subject to a de minimis threshold. Really trivial interests aren't caught. And thirdly, a director will not breach section 175(1) if the transaction is properly authorised by the directors or the members in accordance with the company's constitution. So really, 1 and 3 are the new things here, is authorisation or disapplication in the constitution. Now, these broad principles will catch most cases of unauthorised profits as well, But there is an additional duty which might apply in addition or instead. And that's found in section 176. This says a director must not accept a benefit from a third party conferred by reason of being a director or doing or not doing anything as director. Now, I emphasize the words benefit from a third party. Section 176 is concerned with benefits the trustee receives from a third party. For anything else, such as misuse of the charity's property or the charity's opportunities, you need to rely on section 175. So 176 is fairly narrow. Just like with 175, 176 has some exceptions. For example, 176 doesn't apply to a director who provides paid services to the charity through a service company. And again, it's subject to a de minimis, a trivial exception. Interestingly, though, the other directors cannot authorize breaching of this principle. They cannot authorize one of their number to receive a benefit from a third party. But the charity's members can authorize the charity to enter a contract with a director which gives them a substantial non-cash asset. But that resolution of the members would only take effect if the Charity Commission approves it. So it's quite a narrow and fairly contrived process, but that is one possible way around it. So that's the principles that apply to charitable companies. Similarly, many of the duties of a CIO trustee are set out in legislation, specifically sections 221 to 222 of the Charities Act and regulations 31 to 36 of the general CIO regulations. Now, some of those sections and regulations govern trustee benefits, and in summary, I think you probably need to know 4 things. Firstly, a CIO trustee may not benefit from a transaction with the charity if they didn't disclose any material interest beforehand. So the emphasis is on disclosure. As part of that disclosure process, a trustee who would benefit from the decision can't take part in the decision. Now, helpfully, points 1 and 2 are reflected in clause 7 of the model governing document for CIOs. So if you adopt the model governing document and follow it, these 2 principles are dealt with. Thirdly, if there are insufficient unconflicted trustees to take the decision, then you'll either need to ask the members to approve it, if there are any, or apply to the Charity Commission for authorization. Finally, a CIO trustee must not accept more than de minimis benefits from a third party as a result of their position or actions. That's basically the same as section 176, which we've just looked at. As you can see, these provisions are fairly similar to both equitable principles and the company law principles, but the equitable principles are phrased in broader terms, and it's always important to be aware of both. So all of that is what a conflict of interest is. Let's talk about the next step. What do you do if you spot a conflict of interest? Now, the important thing to remember is that the presence of a conflict of interest does not, by itself, prevent the charity from continuing to act. You just need to properly manage the conflict. And how do you do that? Well, there are 3 main steps. You need to disclose the conflict, address it, and then record the conflict and how you dealt with it. Let me say a bit about each of those stages. Starting with disclosure. The key point is that the trustee must disclose the nature and extent of their interest. Now, the amount of detail that you need to disclose will depend on the size, nature, and importance of the transaction and the size and nature of your interest. The lower the value of the transaction, the smaller the interest, the less you'll need to give. But as a general rule, it's rarely going to be good enough simply to give a general warning along the lines of, oh, I've got an interest in this. What the conflicted trustee really needs to do is ensure that everybody else is fully informed about the nature and extent of their interest. One helpful way of dealing with this in advance is to maintain a register of trustees' interests. That ensures there's a permanent record of potential conflict, and it's generally good governance. So that's stage one, disclosing the nature and extent of the conflict. Once you've disclosed the conflict, you need to decide what else to do. And in every case, a conflicted trustee needs to follow the charity's conflicts policy. This might involve abstaining from the vote on the issue or leaving the relevant board meeting entirely. In more serious cases, the conflicted trustee may be required actively to ensure that the other trustees understand the potential risks. For example, if the conflicted trustee is usually the one who leads meetings or has the knowledge of charity law and duties, they might need to take active steps to ensure that their colleagues understand properly the potential conflict. And in very extreme cases, the conflicted trustee may even need to resign, but that would usually be a last resort. Also, don't be fooled into thinking that resignation solves the problem. You cannot resign with the intention of doing what you're otherwise prohibited from doing. The resigned trustee would still be liable under the principles of conflicts of interest, so don't try and get around it that way. That's stage two, addressing it. The third stage is to keep a detailed written record of the conflict and how you handled it. Now, in practice, your written record should describe who was conflicted, the nature of the conflict, when the conflict was first declared, and what steps were taken to address it. And it's important that you keep those records safely and securely for a good amount of time. Now, sometimes you may not be able to deal with a conflict of interest internally. The most common example is where there are too few unconflicted trustees to take the decision in question. In those circumstances, you can apply to the Charity Commission for an order under Section 105 of the Charities Act to authorise you to act notwithstanding the conflict. And the basic test which the Commission will apply is very familiar. Is the proposed action expedient in the interests of the charity? In practice, as part of that application, the Commission will expect you to give full and frank disclosure of all information relating to the proposed transaction or decision and the potential conflict. That's pretty similar to what would happen if you went to court. Let me talk about that. The court has the power to sanction a transaction which would otherwise breach the no conflicts principles. A claim of this nature is called a blessing application. Now, I don't have time today to go into the detail of blessing applications, but from your point of view, there are three key points. Firstly, fundamentally, the court will ask whether the trustee's view is one which a reasonable body of trustees could reach. That's the basic test. Secondly, when assessing the answer to that question, the court will want full and frank disclosure, just like the Charity Commission. The good, the bad, the ugly, all the documents and information relating to the proposed action and the conflict. And the third important point is that a blessing application is likely to be charity proceedings within Section 115 of the Charities Act. That means you need to get the Charity Commission's permission even to start the claim, and in practice, the Commission is likely to give you advice or authorisation itself rather than permission to issue a claim. So there aren't really going to be very many of these cases in practice, but sometimes, maybe particularly high value or controversial, you might get permission and you might have to go to court. And if you do, it's called a blessing application. So that's how you can manage a conflict of interest. But what can happen if you get things wrong? I said at the start, the consequences can be severe. If you breach either the no conflict principle or the no profit principle, you can face up to 5 potential consequences. Firstly, a transaction that the charity entered that was tainted by a conflict of interest could be set aside by the court. Now, that can cause all sorts of problems for the charity. It can harm the reputation, generally and with suppliers. It can have financial consequences if you have to undo certain things and repay certain money. And practically, it can cause the charity difficulties because it can leave you without the services or the goods that you were trying to buy. Other remedies involve the court ordering the conflicted trustee to pay any profits that they made over to the charity, or paying compensation to the charity for any losses that it suffered. Now, on the one hand, these two options can lead to a windfall, a payment to the charity, but at what cost? Again, reputational damage of litigation, and as we all know, litigation is time-consuming, it's expensive, it's stressful. So at what cost? Remedy 4, if the conflict is serious or persistent, the trustees might be removed from office against their will. Again, this can have reputational consequences for the charity and practical consequences, especially if the trustee in question had a particular skill set which the other trustees really relied on, say they were an accountant or a lawyer. Finally, a failure to manage conflicts of interest properly may amount to misconduct and/or mismanagement in the administration of the charity. That can lead the Commission to opening a compliance case or even a statutory inquiry into the charity. For example, just last week, the Commission opened an inquiry into the relationship between the FIA Foundation, a charity, and the FIA itself, which is the motorsport governing body, a private company. One of the reasons for opening this was conflicts of interest, and there were two potential conflicts of interest of concern. Firstly, the foundation had been making grants to the governing body, the FIA, and secondly, the FIA president, the private body, had been appointed as chairman of the FIA Foundation, and these things are now under review by the Charity Commission. If only the trustees had listened to this talk before they'd got stuck in, eh? Thank you very much for listening. I'll be very happy to take any questions at the end of this talk, but for now, I will hand you over to Amber.
Well, today I'm going to be looking at the potentially tricky issue for charities of making moral payments. We'll come very shortly to what counts as a moral payment, but it will help now to say two things. Firstly, the same principles apply to making payments, transferring property, and waiving entitlements to money and property. So, although I'll be talking about payments, please do bear that in mind throughout. Secondly, often included in the legislation, these payments are referred to as ex gratia, which Google tells me translates from Latin as by favour. But I'm going to adopt the language of moral payments, which the Charity Commission itself uses in its guidance. This is a topic that Matt covered in another talk just under 2 years ago, and some of you may remember that. So you might be wondering why I'm coming back to it again so soon. Well, as many of you will know, some parts of the Charities Act 2022 came into force on the 27th of November last year, and that included sections 15 and 16, which inserted two new sections into the 2011 Act, and also amend section 106 of the 2011 Act. All of those sections are concerned with the making of moral payments. The Commission published updated guidance, CC7, to reflect the statutory changes on the same date, so it seemed like a good time for an update. This is also a topical issue. In fact, one of the reasons why there was such a long delay between the 2022 Act being passed and the provisions that we'll be looking at today coming into force was because there was concern about potential unintended consequences for the return of certain cultural objects. Something like the Elgin marbles or the Benin bronzes would spring to mind. You might want to have a think about whether you feel that charities should be able to divest themselves of such objects, even where it doesn't further their purposes. And I'll return at the end of the talk to where the government ended up getting with that issue. So, with that context in mind, let's have a look at the law. Starting with the basics, what is a moral payment? Well, firstly, we need to distinguish a moral payment, which is one where the obligation is only a moral one, what we might call pure benevolence, from a different category of payments, which might be called quasi-commercial, or coming from a place of enlightened self-interest, or which are reasonably incidental to the charity's purposes. An example of a quasi-commercial payment of that type would be giving a pension to a charity employee which exceeds their contractual entitlement. therefore making the charity look like a good employer, which will benefit the charity in the long term. And the reason we need to distinguish carefully here is that no special power is needed to make that kind of quasi-commercial payment, although the terms of the governing document should, of course, be checked to see if there is a suitable power and because they may contain a restriction. But it suffices to say that a broad power, for example, to do anything incidental to further the charity's purposes, might be used in those circumstances. As to purely moral payments, the Commission envisages a number of different scenarios, and I'll talk you through a few of those examples now. One is in the context of wills and legacies. So, a person might leave money in their will to some named grandchildren and also to a charity. They welcome a new grandchild and they make arrangements to change their will to include the new grandchild, but they die before signing the new will. The charity in those circumstances might want to honour their testator's intention by giving some money to the new grandchild. Another example might involve a person who's donated money to a charity, believing that they can afford to do so, but then realising that in fact they couldn't and experiencing financial difficulty as a result. That person might write to the charity and ask for part or all of their donation to be returned. The third example falls into a slightly different category, a more unusual category, and involves a charity holding a painting which was unlawfully removed from its owners during the Second World War. The heirs of the owners might get in touch with the charity and ask for it to be returned. So those are the moral cases. In Re Snowden, which is the case that I've taken a lot of this language of benevolence and so on from, Mr. Justice Cross recognised that the Attorney General and the court both had power to authorise charity trustees to make moral payments in circumstances where it could be said that if the charity were an individual, it would be morally wrong for them to refuse to make it. That power has since been put on a statutory footing, as we will see. So, in summary, it's a moral payment if it's one that the trustees could reasonably be regarded as being under a moral obligation to make, but they're not under any legal obligation to make it. Their governing document doesn't have any powers which can be used to make it. There are no other legal powers which they can use, and they can't justify it as being in the best interests of the charity. Now that we know what a moral payment is, that brings us on to the question of how the trustees can go about making one. And the first option is what I'm calling the internal route because it can be done by the charity on its own. This is a new power for charities, which was introduced by the 2022 Act, so it's important that charities understand how and when they can use it. The power comes from Section 331A of the Charities Act 2011, which is one of the new sections. And the section tells us that trustees may make any application of charity property or waive to any extent on behalf of the charity its entitlement to receive any property if three conditions are met. The first condition is that the value of the property does not exceed the relevant threshold. I'll talk through the relevant thresholds shortly. They're set out in the section itself in subsection 6, but the important thing to be aware of is that they are quite low. The second condition is that the charity trustees have no power to take the action apart from this section or by virtue of section 106, which is the section which gives the Attorney General, the Commission, and the court power to approve moral payments. So before going down this internal route, the trustees need to consider carefully whether those 4 points we looked at before really apply. Is there a power within the document to make, the governing document to make the payment? And the third condition is that in all the circumstances, the charity trustees could reasonably be regarded as being under a moral obligation to take that action. So this is now an objective test, looking at whether in all the circumstances they could reasonably be regarded as being under a moral obligation. This also applies to what I will call the external route, so we'll consider that altogether shortly. There are some additional considerations for the trustees exercising this new power. Firstly, the Commission's guidance confirms that trustees can delegate their authority to decide whether they could reasonably be regarded as being under a moral obligation to others in the charity. while remaining ultimately responsible for all decisions made. The delegation could be to a specific subcommittee of trustees, to the CEO, to a legacy officer, or somebody else, depending on the specific charity. The trustees might circumscribe the delegated authority, for example, by limiting the maximum value that the delegate can make decisions about in each year, or by imposing a risk-based limitation. If the trustees do decide to delegate, that decision should be recorded. The delegate should be given clear terms of reference, and there should be reporting and review procedures in place. Secondly, the trustees must consider what is required to substantiate a claim to a moral payment. In a will case, the Commission's guidance explains that a statement by a person who believes they're morally entitled to a share is not normally enough on its own because it's not impartial. Instead, the Commission says trustees might look for evidence of the deceased's intentions in the form of a draft will or a written statement from an independent person, like a solicitor. And that might include evidence as to the circumstances in which the testator couldn't validly update their will in time, such as a sudden illness. However, the guidance does say that if there is no stronger evidence available, then a statement from a non-impartial person might be enough if it's supported by a statutory declaration. And in a case where a donor's circumstances have changed, where they've made a donation but then realised that they can't afford it, evidence from the donor themselves and from third parties such as doctors is likely to be relevant. Finally, a clear record of the decision, the reasons for making it, including the evidence and factors considered, needs to be kept. Whether the decision is taken by the trustees or by a delegate, it should be clear that they've considered the tests that we've looked at. So, in the case of trustees, they should record that they reasonably regard themselves as being under a moral obligation to make the payment, and they should record that either in a trustee resolution or in the minutes of a trustee meeting. In the case of a delegate, they should record that they believe the trustees could reasonably be regarded as being under a moral obligation to make the payment, and they should follow the reporting and accounting arrangements that are in place between them and their trustees. This internal route does come with some limitations. Firstly, section 331A, subsection 4, confirms that the power can be restricted or excluded by the trusts of the charity. Having said that, the Charity Commission's guidance in CC7 explains that a general restriction, something like only apply the income and property in furtherance of the charity's purposes, does not prevent trustees from using the legal power to make moral payments. This is clearly something to consider when drafting or amending government documents for charities, governing documents for charities, to consider whether that you want the trustees to have that power or not, and how to word the governing document to achieve that result. Secondly, the relevant thresholds are relatively low. As you can see from the table, for example, if a charity has a gross income in the last financial year not exceeding £25,000, then the threshold is £1,000. But even in the case of a charity whose gross income was over £1 million, the relevant threshold is 20,000. These thresholds can be altered by secondary legislation, so we will likely see increases in time, but there's no guarantee that that will be a regular occurrence. If the moral payment would exceed the relevant threshold, then the internal route will not be available. An authority must be sought from the Commission instead. Likewise, if the governing document prohibits the payment or if it imposes a restriction which the trustees wish to exceed, and it's important to remember that the threshold cannot be circumvented by splitting a payment into two or more tranches. There is also a further limitation for some statutory charities, which I'll cover separately shortly. So the other option for trustees who wish to make a moral payment is the external route. Section 106 of the 2011 Act, as amended, now allows the Commission, the Attorney General, or the Court to authorise the trustees to make any application of charity property or waive to any extent on behalf of the charity its entitlement to receive any property if two conditions are met. The first is that the trustees, apart from by virtue of this section or section 331A that we were just looking at, have no power to take the action. But the second condition is, in all the circumstances, the trustees could reasonably be regarded as being under a moral obligation to take the action. And this is a departure from the previous section 106, which allowed the Commission to authorise an action if, in all the circumstances, the trustees regarded themselves as being under a moral obligation to take it. So we've switched from a subjective test to an objective one, and now we can see that the test is the same in all cases. So what are the considerations relevant when taking the external routes? Well, CC7 is a very helpful guide here. Um, an application should be made to the Commission by the charity trustees or those with delegated authority or their representatives, but it cannot be made by the person who wants to receive the payment. The Commission will require firm evidence that the payment is justified. Generally, that will be impartial evidence as to why, for example, a testator's real intention was frustrated. Supporting documents will need to be provided, and a full list of what is required is included at section 5 of CC7, which includes any legal advice received if the trustees feel it can be shared. It's clear as also from section 106 that the Attorney General continues to play a key role in this area. Subsections 3 and 4 of section 106 provide that the Commission's power to authorise moral payments is subject to the supervision and directions of the Attorney General. And even if there are no directions precluding the Commission from exercising the power or requiring it to consult the Attorney General, if it receives an application which it considers it would be desirable for the Attorney General to entertain, then it must refer the application to the Attorney General. And the Attorney General might in turn refer the question to the tribunal or the court. If the Commission refuses an application, that doesn't necessarily preclude an application by the trustees to the Attorney General, who may then exercise the power instead. The trustees can also appeal a Commission decision to the FTT or apply to the court for approval. But such proceedings would be charity proceedings for the purposes of the 2011 Act. So we've seen that the test in section 106 has changed from a subjective test to an objective one, and that the same test is used in section 331A. We don't yet have any cases on the objective test, but CC7 contains 7 different examples which are instructive. I'm only going to go through 2 of them now. The first one I find quite interesting because it's the only negative example that the Commission gives, in the sense that it's one where they say that the trustees can conclude that they aren't under a moral obligation to make the payment. So this is a case involving person E, who I'm going to call Eric, who's partway through writing his will. Eric inherited his wife's estate when she died, and he wishes to leave his estate to some of her relations. However, he dies before he finishes making his will, and his estate passes to his brother Fred under the intestacy rules. When Fred dies, his estate passes to a named charity under the terms of Fred's will. And that includes what Fred had inherited from Eric. Eric's relations, who would have benefited under Eric's will if it had been executed, asked the charity to consider making a moral payment to them. They say that Eric's estate was never meant to go to Fred or to the charity. The trustees consider the request and conclude that there is no evidence that Fred's will did not reflect Fred's intentions, and they don't consider that they could be reasonably regarded as being under a moral obligation to make a moral payment in those circumstances. As I say, this is the only negative example that the Commission gives, so I find it particularly helpful. And And it's worth bearing in mind that the guidance reminds trustees that disappointed relatives are not enough on their own to justify a moral payment. A second example is of a church having an informal arrangement with its pastor to pay a monthly allowance, but only as and when the church can afford it. When the pastor dies unexpectedly, the trustees acknowledge how hard he'd worked over the years and that the church's inability to make the monthly payments on a regular basis had caused the family financial hardship. The church is now better off financially, and the trustees decide that they could reasonably be regarded as having a moral obligation to make a one-off payment to the pastor's widow. So all these examples help us to see in what circumstances it's thought that trustees could reasonably be regarded as being under a moral obligation. The second example in particular raises a point as to the extent of the moral obligation. So it is important to be aware that if there is a moral obligation, it might not require payment of the full anticipated benefit, and this should be considered carefully. So, for example, consider a case where disappointed beneficiaries have a claim in professional negligence against the drafter of a will. And in that case, the level of moral obligation on the charity might be affected by how strong their claim would be against the will drafter, for example. All in all, these decisions aren't to be taken lightly. The Commission stresses that requests or proposals should be considered carefully, and noting that moral payments will reduce what's available to the charity to spend on its purposes. And if in doubt, the trustees should take professional advice. So finally, I wanted to touch briefly on statutory charities. And these are charities who are established by or whose purposes or functions are set out in legislation. Legislation is widely defined to include Acts of Parliament, Acts of the Welsh Parliament, and subordinate legislation, and also measures of the Church Assembly or of the General Synod of the Church of England. As you'll see from the quoted text here, both the amended Section 106 and the new Section 331A contain special provision reversing the decision in Attorney General and British Museum trustees by saying that a payment can be authorised even though the relevant legislation prohibits application of property otherwise than as set out in the legislation. So this is now the position, at least as regards statutes which were enacted before Section 16 of the Charities Act 2022. However, some interesting questions of statutory interpretation might arise in relation to charities established by later statutes, which don't deal expressly with whether they partially repeal or take precedence over these amended sections. However, and this is a big however for the more newsworthy cases that I mentioned earlier, both Section 331A and Section 106 are in force only, except insofar as they relate to excluded property of a relevant charity. So, while statutory charities can make moral payments in the ways we've looked at today, there are 16 relevant charities who cannot transfer certain property using this power. These charities are principally museums that include the British Museum. So, in the example of a charity returning a painting that had been taken during World War II, one of the steps that that charity would need to take is to consider whether it was a relevant charity, and if so, whether the painting was excluded property. Because if that was the case, it wouldn't be able to use the moral payment power to return it. Just recently, the Department for Culture, Media and Sport has committed to review the implementation of the relevant sections of the 2022 Act, including this exclusion, following criticism by the Joint Committee on Statutory Instruments, which asked for an explanation of the intention behind it, including whether it's going to be temporary or permanent. DCMS has responded, saying that the exclusion reflects the government's view that the bodies listed should remain bound by the restrictions imposed by their governing legislation, pending a proper consideration of the impact of allowing them to dispose of objects from their collections. So we'll just have to watch that space. Thank you.
I think we are rapidly running out of time. Thank you very much, everyone, for coming. We hope that you found this webinar useful. If you have any further questions about either topic, please feel free to reach out to Amber or me. If you need more CPD or just an afternoon away from the office, check out our commercial conference, which we will host on the 18th of March in London near Fenchurch Street. My brilliant colleagues will cover lots of useful topics, including secret commissions, a conflict of interest if I ever heard one. And in the meantime, if you miss our lovely faces, you can follow Radcliffe Chambers on LinkedIn to find out more information about our work and upcoming events. We hope to see you soon. Thank you very much. Bye-bye.
Thank you. Bye.